Hi, hello, how are you all? Welcome to my channel Law Made Simple with me Vidyarthi. Today, in the series of company law, let us learn about who is a director and what are his rights and duties. The invisible and intangible nature of the company makes it obligatory for this corporate body to appoint some living person or persons through whom it may act and carry on its business. Such persons are usually called directors of the company. Section 2 Clause 3(4) of the Companies Act 2013 defines the term director as any person appointed to the board of company. Section 149 of the Companies Act 2013 provides that every company shall have a board of directors consisting of individuals like directors and shall have a minimum of 3 directors in the case of public company and 2 directors in the case of private company and 1 director in the case of one-person company. Maximum of 15 directors by passing a special resolution also. So, who are the kinds of directors? There are first directors, additional directors, alternative directors, nominate directors, director appointed as in casual vacancy, independent directors, executive directors, and whole-time directors. Let us look into the powers of the director. The board of directors are entitled to exercise such powers and to do all such acts and things as the company itself are authorized to exercise to do. Generally, the powers of the board are delineated in the Articles of Association, but these powers can be exercised subject to the restriction imposed by the Companies Act under Section 292. The powers to be exercised by the board are exhaustive in nature, and while some of these can be exercised by the board, some other powers can be exercised subject only to the approval of shareholders like Section 293, 293A, 297, etc. Again, there are certain other powers that can be exercised only with the approval of government like Sections 294A, 295, etc. So, these are the powers of the director. Coming to the rights of the director, the Act has conferred various legally enforceable rights on the directors. These rights can be classified as individual rights and collective rights. As in individual rights, the rights of the director are right to inspect books on accounts, receive notices of board meetings, to receive draft circular resolutions, to receive sitting fee, to be heard at the general meetings. He has the right to inspect minutes of board meetings, right to record his dissent, right to participate and vote at board meetings, right to claim travel, stay and other expenses, right to summon board meetings, right to ask the board to appoint alternate director also. What are his collective rights? They have the right to refuse the transfer of shares, right to elect a chairman, right to appoint a managing director, right to recommend dividend, right to approve investments. Coming to the duties of the director. In the matter of proceedings for negligence, default, breach of duty, misfeasance, and breach of trust, the Companies Act and the rules do not make any distinction between whole-time or the part-time directors. Liability for those acts are equal. However, part-time directors may be relieved from the liability when no evidence of the fact that they exercised control in any matter is brought in forth. So we know that the directors of the public companies are their agents and even though regarded as strangers, but as regard to the shareholders, they are always clothed with fiduciary character with reference to any dealings with the property of the company. A director is in a fiduciary position and is expected to protect the company's interest and not to utilize his position and knowledge possessed by him by virtue of his office to the detriment of company's interest and for his personal gain. The director of the companies are trustees in a limited sense. He is only liable for the breach of trust if he misapplies funds or misappropriates the assets. Coming to the duties of the director are fiduciary duties of loyal and good faith, duties of care, skill and diligence, collective duties of directors under company law, individual duties of directors under company law. Coming to the fiduciary duties, the director occupies a fiduciary position in a company. A fiduciary position refers to a position of trust and confidence. The fiduciary position of directors requires them to act very honestly and in good faith. Duties of care, skill and diligence. In India, there is no specific provision regarding to the duties of care, skill of the director in the Companies Act. Courts have mostly been following English decisions and common law rules. A director must take of what an ordinary man might have been expected to take in continuing the effects of the company. He is not an insurer to the success of the company. A director's duty has been laid down as requiring him to act with such care as a reasonable person is expected from him having the knowledge and experience. The directors are not liable for mere errors of the judgment. They are not born to give continuous attention to the company. A director is liable only for the gross and culpable negligence. In contrast, a far degree of skill and commitment to the company will be expected from the managing director and the executive director or whole-time directors. Coming to the collective duties of directors in the company law. His duty to investment of funds, no misstatement in the prospectus, the holding of annual general meetings, filing certain resolutions like appointment and reappointment of managing director, directors report, appointment of auditors, holding of board meetings. These are all his collective duties under company law. To the individual duties of directors under company law. Some of the individual duties are his duty to attend board meetings, duty to file his consent to act as a director, duty to take qualification chairs, duty to abstain and discuss and vote in which he may be directly or indirectly concerned or interested in. Coming to the responsibilities of directors, to bring an independent judgment to bear on issues of strategy, performance, resources, including key appointments and standards of conduct, to be independent of management and free from any business or other relationship which could materially interfere with the exercise of their independent judgment. As such, we have come to the end of the session. It's riddle time. Please answer the riddle in the comment section. Please like, share and subscribe. Thank you.